Hello, good afternoon, everyone. Thank you very much for joining us today on today's MLI webinar. My name is Aaron Woodrick. I'm the director of the Domestic Policy Program at the Macdonald-Laurier Institute, and very pleased to be moderating today's discussion on the Notwithstanding Clause. All the constitutional law nerds tuning in with the theme of use it or lose it. Obviously, a very timely debate, and to discuss the topic today, I'm very pleased to be joined by two experts in the area. We've got first Dave Snow, Assistant Professor of Political Science at the University of Guelph, and also Leonid Sirota, Associate Professor of Law at the University of Reading, joining us from across the pond. Gentlemen, thank you both for joining me today.
Thanks for
Nice.
having us.
Thanks for having us.
Thanks, gentlemen. Now, lots to talk about today, of course. As I mentioned, a very contentious topic, but I wanted to perhaps start by maybe giving each of you just a couple of minutes off the top to talk a little bit about your views on why the recent news around Section 33 is significant in your view. Before we get into the use it or lose it portion of the discussion. So, Dave, maybe I'll start with you.
Sure. Thanks, Aaron, and thanks, Leonid, for coming here, and thanks everyone for tuning in. I'm really looking forward to this opportunity. What I'm going to do is say a few words about the what the Notwithstanding Clause is and its history and its use. I guess to the extent that we have one, I'm on the use it side today, but I'm going to explain a little bit as well a recent paper I wrote for the Macdonald-Laurier Institute and my general argument about why I found the Notwithstanding Clause most recent use in the province of Saskatchewan to be perfectly fine, perfectly acceptable, regardless of what one thinks of the policy area. So broadly, the Notwithstanding Clause allows a provincial legislature or the federal parliament to declare an act or provisions of shall operate notwithstanding any provision in section 2 or 7 to 15 of the Canadian Charter of Rights and Freedoms. The Notwithstanding Clause is part of the Charter of Rights and Freedoms. It's section 33 of the Charter. And those sections are really important freedoms that they list. The fundamental freedoms like freedom of thought, belief, opinion, and expression, freedom of religion, our legal rights, including the right to life, liberty, and security of the person, and our equality rights. So essentially what the Notwithstanding Clause does is gives the provincial legislatures and the federal parliament the ability to pass laws that shall operate notwithstanding those sections. It does have a sunset clause, which means that it ceases to have effect after 5 years if you pass a law, but a legislature can reenact it. And as legal scholar Dwight Newman has summarized, the real reasons behind the Notwithstanding Clause, if we look at the political thought of the framers of the Charter, were twofold: to protect rights beyond those enumerated in the Charter when Charter case law interferes with those rights. So in particular, NDP Premier Alan Blakeney from Saskatchewan was really big on concern that the judiciary might strike down laws that enabled public health care, universal health care. And he thought that we had a right to health care, and he wanted to ensure that legislatures would be able to protect that. And second, and the one I think more people are familiar with, is the ability of legislatures to engage with and disagree with judicial interpretations of rights, because the rights in the Charter of Rights and Freedoms are listed in very broad language: the right to life, liberty, security of person, the right to freedom of thought, belief, opinion, and expression. And so really, when we look at sort of policy disputes that happen with respect to the Charter, it's all about judicial interpretations of what that broad language means. And so over our history, you'll often hear a lot in the media about how the Notwithstanding Clause was barely used until recently. And I think a lot of that is sort of myth-making based on the past. So my research has shown, and research of others, first and foremost, it's been used a lot by Quebec. Quebec used the Notwithstanding Clause on dozens, if not hundreds, of laws as soon as the Charter was passed as a form of protest. Applied it to every law it ever passed, and then every new law from 1982 to 1985. And then in the sort of 30 plus years since, it was used 17 times in unique legislation, 14 of those by Quebec. So it's absolutely true that the Notwithstanding Clause very infrequently used outside of Quebec, and for about 25 of those years, even quite infrequently used inside Quebec. And then since 2018, we've had a political revival where 8 bills have been introduced at the provincial level invoking the Notwithstanding Clause. 6 of those have passed. Now, a couple haven't come into force or haven't remained in force for various reasons. But what sort of set up this seminar and interest in the Notwithstanding Clause is Saskatchewan's Parental Bill of Rights, which was passed last Friday, which invokes the Notwithstanding Clause and does so in response to an injunction at the Saskatchewan Court of King's Bench, and that sort of paused a similar policy that wasn't in law. And what the Saskatchewan bill does is it stipulates that parents have the right to be informed and to be consulted for various things, including, most controversially, that the parent has a right to provide consent before a pupil's teachers, and here I'm quoting from the law, or other employees of the school use the pupil's new gender-related preferred name or gender identity at school, if that student is under the age of 16. So if a student wants to formally change their name and or gender pronouns at school and they're under the age of 15, this Bill of Rights, this piece of legislation passed by Saskatchewan, says that that the parents need to consent to that change. Uh, Part of the reason that I wrote a paper for the Macdonald-Laurier Institute was that the media commentary on this bill was particularly apoplectic, as is often common with any commentary on any use of the notwithstanding clause. We heard things like the notwithstanding clause is the nuclear option that will destroy the rights of students, a horrifying idea, these sorts of things. And in this paper and in this panel, I offer no commentary on the policy itself. But suffice it to say, I've read the arguments from both sides, and I do think both sides of the argument, the Saskatchewan government and the opponents of the bill, are making their arguments in good faith. But what's so interesting about this use of the notwithstanding clause is it is a classic issue of what political scientists have long called a clash of rights, where both sides of the issue are using the language of rights. The law is called the Parental Bill of Rights. It's about protecting parents' rights. And on the other side, we see the language of LGBTQ rights and privacy rights and international human rights agreements and the right to gender expression. And what I argue in the paper is that on both these sides, the Charter contains no textual basis for either sets of rights. It's possible, perhaps even probable, that a judge might find that these rights exist in this particular case. But there's also no obvious applicable Supreme Court jurisprudence. There's no case that obviously leads one to say, well, obviously this law would get struck down. Now, obviously, the Saskatchewan government thinks that its law would get struck down, or else why not include the notwithstanding clause? But I conclude, and I'll conclude this brief introduction by saying, when we look at the history of the notwithstanding clause and we look at this policy dispute, this is exactly the type of issue for which the notwithstanding clause was envisioned. It's reasonable disagreement with a judicial decision or existing jurisprudence, whether we're talking about the Saskatchewan injunction or an expected outcome based on Supreme Court jurisprudence in an area of clear provincial jurisdiction over a clash of rights that is not directly contained in the text of the Charter itself. And so we'll call it judicial activism. A lot of people don't like that term, but broadly speaking, courts in the Supreme Court going beyond the text of the Charter, beyond the scope of what was expected, has led to an increasing number of issues being seen to be as beyond the scope of legislative authority over the years. And while we certainly should not necessarily celebrate every use of the notwithstanding clause, and I personally oppose some of the bills in which it was used on a policy, from a policy standpoint, I do think that Saskatchewan's policy is a reasonable policy on which reasonable people disagree, and it's exactly the type of issue for which the notwithstanding clause was intended to be used and put in the Charter. So thank you.
Thanks very much, Dave. Leonid, your turn.
I think the recent series of uses of the notwithstanding clause is indeed very significant because it reflects, to my mind, push to undo the constitutional settlement of 1982 and eliminate those provisions of the Charter to which the notwithstanding clause can be applied as a binding constraint on Canadian legislatures. Professor Snow has explained that ultimately, on his view and on the view of those who are in this camp, the use it camp, reasonable disagreement is apparently sufficient to justify a legislature in imposing its own vision or allegedly its own vision of rights to the exclusion of whatever the courts might be able to say about those rights. Well, as scholars like Jeremy Waldron and others remind us, questions of rights generally are subject to reasonable disagreement. If reasonable disagreement is sufficient warrant to oust judicial interpretations of the Constitution, we should not have judicially enforceable constitutional protections for any rights at all. And that is very much the direction in which we are going. Notice also the speed at which we are proceeding there. So let me quote something that Peter Lougheed said. As Professor Snow mentioned, he was one of the chief proponents of the Notwithstanding clause being included in the charter, and he said afterwards in the late 80s, I think. So he said that a legislature, when it is considering whether to use the Notwithstanding clause, a legislature should consider the importance of the right involved, the objective of the stricken legislation, the availability of other, less intrusive means of reaching the same policy objective, and a host of other issues. Professor Dwight Newman, who Professor Snow has also mentioned, said that the political responsibilities of governing mandate that each use of the Notwithstanding clause must be carefully contemplated in light of its effects on rights, on the rule of law, and on Canadian constitutionalism generally, all the while considering the salutary effects in terms of rights or other weighty moral considerations of the policy goals pursued through the legislation at issue. Well, that is not what is happening in the last few years. And in this respect, I'm glad that Professor Snow hasn't shied away from the early history of the Notwithstanding clause and its use by petulant governments in Quebec, because this early history, in fact, is past is prologue for what has been happening more recently. It is still an example of petulance upon petulance. Legislation invoking the Notwithstanding clause has been enacted in midnight sittings of the Ontario Legislative Assembly. It has been rushed in a matter of weeks, as is now the case in Saskatchewan, or indeed in days, as has been the case in Ontario. Far more often than not, and Quebec, actually, to its credit, despite the substantive terribleness of the legislation at issue, but Quebec has actually gone through serious debates and select committee study for the bills that it passed invoking the Notwithstanding clause. That generally has not been the case, or hasn't been the case at all in the other provinces, again, Ontario and Saskatchewan being the worst offenders. No select committee scrutiny to speak of, or at all in those cases. So what we are looking at is legislatures which are no longer really disagreeing with some established jurisprudence for the Supreme Court, with the partial exception of Quebec here. They are simply being petulant in response to lower court decisions, in the case of Saskatchewan, in response to a decision which did not reach a substantive view on the rights involved at all. It's a preliminary decision. It may or may not point to how the court would actually have ruled in the end, but again, only a court of first instance, not even a court of appeal, let alone the Supreme Court. And yet the political response is to rush and exclude the application of the charter and exclude the ability of people concerned to seek judicial remedies against legislative overreach. So to my mind, we are looking at the crumbling of a constitutional order that has served us better than not perfectly by any means. Courts certainly make mistakes, and I think one of the more vocal critics of the Canadian judiciary, at least in the ranks of academia. But a constitutional settlement that nonetheless has served us on the whole well, and it is being unraveled by petulant legislatures.
Great. Thank you, Leonid. Well, this is why I make sure I have people that don't have an identical view on an issue on a panel. It wouldn't be much fun if we had that. But so, gentlemen, I mean, we could get into the classic argument about, I think there are some people who think, Section 33 is an abomination. It should be removed from the Constitution or never used. And there are others who sort of take the view that anything goes. I mean, this is a legitimate tool for the legislatures to use when they see fit. And if in some cases the standard that's necessary, as Leonid had alluded to, is simply reasonable disagreement. Sort of, we can use it any time. But I think amongst most people, there's probably an acknowledgement that this is part of the bargain that brought in the charter. So there are going to have to be at least some circumstances in which it's used. It's just a question of what those parameters are. What are the rules and norms that would be acceptable to use Section 33? So Leonid, maybe I'll start with you on this. You talk a lot about how there's this rush now, and that you're sort of implying that it might be okay if governments use Section 33 if they demonstrate that they've thought long and hard about it and looked at alternatives, but that's not what's happening. Governments are just sort of using it as the nuclear option right away. So I guess my question to you is, how what is responsible for the change in those norms? And rather than just politicians using it for political purposes, do the courts bear any responsibility for the increasing use of it?
Just first of all, to correct, I hope I haven't given the impression that I would be okay with uses of the notwithstanding clause that are considered along the lines of what Lougheed and Professor Newman suggested. I'm taking the advocates of the notwithstanding clause at their word and saying that what is actually happening falls well short of what they have been promising us. I think it should never be used at all. Now, what has changed? I think it's a meme as much as anything else. I think that once Saskatchewan broke the taboo, and so it first used the notwithstanding clause in 2017 in a decision that had to do with the ability of non-Catholic students to attend government-funded Catholic schools. A decision which was eventually overturned by the Court of Appeal, incorrectly as I see it, but it was overturned. And so once other provinces, in particular Ontario, saw that, well, they can do it and they can get away with it, I think Mr. Ford decided, well, why don't I try to use it and see if I can get away with it? He did. Uh, Quebec has always been a somewhat different story. Uh, there has never been a norm against the use of the notwithstanding clause in Quebec. So Quebec, I think, is different, but in the other provinces, it was just something that wasn't done before, and then it was done once, and then people started doing it again and again. Are courts responsible? I personally don't think so, because the if you look at the actual cases in which it has been used, uh, the initial one in Saskatchewan, again, that decision was overturned. I don't think it was wrong, but it was overturned. In Ontario, the notwithstanding clause was used in some election law matters in response to cases which were actually very straightforward and not novel. Uh, in New Brunswick, it was proposed to be used in an area where there simply wasn't any relevant jurisprudence, and the same seems to basically be true in Saskatchewan as well, as Professor Snow explained. So you can think of, maybe everyone has his or her own list of cases where Canadian courts have gone overboard. You can call it activism if you like. I don't like this word. But actually, the cases in which the notwithstanding clause has been used just aren't. I don't think they would be on anybody's list of those instances where the courts have done crazy things.
I want to get Dave in here, but I want to push back on one thing you said, Leon, at first. I mean, you mentioned the sort of Ford government using it willy-nilly. I'm sure you're familiar also with the instance where they ultimately threatened and then withdrew the use of it over a labor dispute with the unions. Does that not suggest that there might actually still be some circumstances and norms where, the public would see and the government felt that they were constrained in its use? Because otherwise, why would they have withdrawn the use in that one instance?
If I remember correctly, they did enact it and then they repealed the legislation.
Yes.
Uh, I mean, if they got it, that was intended for a very specific purpose. They did settle the dispute, and I mean, the fact that they were able to use the notwithstanding clause may have had something to do with the settlement that was eventually obtained. So I'm not sure which way that cuts.
Hmm. Dave.
Great. Well, actually, yeah, I agree with Leonid that on the sort of proximate cause of Saskatchewan's use being the catalyst that has begun this, and I'll give credit to Leonid who kind of predicted this in 2017 that this was going to perhaps open the door. I guess I disagree on the extent to which this is a problem. I think Saskatchewan's initial use was so mundane. It is such a I think we disagree on the outcome of this case, but it is a difficult case to explain sort of whose rights were being violated in the first place. It was a case where Saskatchewan was funding Catholic schools, which it is constitutionally permitted to do, and this judge said you're not allowed to fund non-Catholic students to attend these Catholic schools. And so there was a real strong practical reason for Saskatchewan to use the law that they claimed that tens of thousands of students would be forced to move schools suddenly. And I think with a lot of the notwithstanding clause uses, we see that practicality. And I think this actually gets to the point that Leonid made earlier regarding speed. And I'm glad that you mentioned the Quebec law, because we often hear this argument that the notwithstanding clause uses are being sort of rammed through legislatures at speed. But as the Quebec Bill 21 shows, for most people, to the extent that these uses of the notwithstanding clause violate rights, Quebec's is arguably the most violating and the most egregious use of the notwithstanding clause. The Quebec government took something like exactly a year to debate this through its legislature, and the law was no less rights violating than it was at the beginning. So to me, there's no direct connection between the egregiousness of the rights violation and the speed at which it goes through the legislature. And so what we're seeing here in these situations, is it true? Could they be more carefully contemplated? Would I like to see more committee hearings where government ministers are citing relevant Supreme Court jurisprudence? Of course. But what's sort of going on here is that let's use the example of the Parental Bill of Rights in Saskatchewan, and this certainly applies to the Ontario back to work legislation a year ago as well. There's a situation going on. There's a policy change the government wants to involve itself in. The government thinks that this is something that ought to be dealt with pretty quickly. We think Saskatchewan kids going to be out of school. In Saskatchewan's case recently, students are changing their gender pronouns at school, and this is being kept from parents, and we, the Saskatchewan government, think this is a bad thing. Ontario, there's an ongoing strike and kids are out of school. Their advisors say to them, this is the relevant jurisprudence, and this is why we think that if you bring this law in, it's going to get struck down really, really quickly, and we're going to be back to square one. And the Saskatchewan or Ontario government are saying, well, we don't want that. We think that this policy is justified. We think that this is an important and pressing policy issue. We disagree with the court on what the important rights and values are at stake and which ought to be given precedent. And we have this instrument, the notwithstanding clause, that we're willing to use. And I think what we often hear from people is, you should wait. You should wait until one court, and you'll often hear others say, wait until it gets appealed all the way up to the Supreme Court, right? Teachers are striking, kids are out of school. Let's wait 3 years to hear if the Supreme Court says that your law violates the Charter, even though we know based on its jurisprudence that that's probably what they'll find. And I would point to the Saskatchewan Court of Queen's Bench injunction, where, yes, the judge didn't rule on the charter issues per se, but the nature of the injunction, the fact that the judge said, I'm putting this in place because it's more likely to cause irreparable damage to children than to not. That's an interpretation. It's not one everyone disagrees with. But I think the Saskatchewan government read the writing on the wall and said, okay, if we wait, as people are telling us to wait, it's just going to happen again in 3 months where we're back at square one. We think this is an important issue. We disagree with the judge on this rights interpretation, and therefore we want to bring this law in as it stands. So for important things, you pass bills quickly. And I think that the speed at which bills are passed containing the notwithstanding clause bears no direct connection to the egregiousness of the rights violation. And I'll just say finally on the sort of what has changed since 2017, I will disagree with Leonid here as well. I do think that when we look at the governments that are passing the laws, there are 4 conservative governments who have introduced legislation. New Brunswick's never passed, but they're all nominally conservative within their province. And I do think that there is a perceived ideological uniformity, especially over the last 8 years, between judicial decisions and the federal cabinet, or the federal government specifically. And especially during the Trudeau years, there's a perception that, especially for premiers who are a little more concerned with provincial jurisdiction, the deck is stacked before the game begins. We know what these judges are going to decide because lawyers are progressive, judges are progressive, and by the way, the federal government has a monopoly over judicial appointments, not just of the Supreme Court, not just of federal courts, but of all provincial superior courts as well. And so that certainly applies with Saskatchewan's Parental Bill of Rights. If I were advising the Saskatchewan government, what do you think any random judge appointed to the Saskatchewan Court of Queen's Bench is going to rule on this issue, even though there's no jurisprudence? I would say I would guess with a high degree of certainty that they're going to say this law violates the charter. So in that instance, I'm not saying we should blame judges, but nor should we blame governments for anticipating that judges are going to rule as they have been, which tends to be on the progressive side of these complex policy debates. So I think in that sense, that sort of had we had decades of conservative governments appointing decades of very conservative judges, I'm not sure we would have seen the notwithstanding clause use in the same way. And if we did, it might be more in the progressive direction on things like protecting the public healthcare system and that sort of thing.
Okay. Lena, I want to go back to you, and I apologize for mischaracterizing your position. I didn't mean to do that. If your view is, in fact, that the Section 33 should never be used, I guess then, I mean, my question to you would be: is this a original sin of the charter situation? How do you reconcile the view that it should never be used with the fact that we wouldn't have a charter if we didn't have Section 33? So, if the charter is so important that we can't use Section 33, aren't we trapped in this sort of contradiction where that, having the ability of governments to disagree, at least in some conceivable case, as a prerequisite to having the charter in the first place? I'm curious as to how you'd square that circle.
I don't see a contradiction there. We probably wouldn't have a confederation without the federal power of disallowance. So a power for the federal government to um, annul, in effect, provincial legislation, but that power should never be used. It would be unacceptable for it to be used as we have come to understand federalism over the course of Canadian history. So ideally, the notwithstanding clause would have the exact same status as the federal power of disallowance. It would be there on paper, and there would be a constitutional convention that says that using it is absolutely illegitimate. Now, I don't think we were ever there so far, and certainly we aren't anymore. But that would be the ideal for me. There is just nothing new or surprising or illogical about it. It was, if you will, you can call it the original sin. It was the political compromise that was made, but we are not bound by that political compromise. It's up to the governments in this day and age to act in accordance with principle, and that should mean that they never use the notwithstanding clause.
Dave, maybe to play devil's advocate with you a bit on this too. I mean, if the argument is that the charter is supposed to protect fundamental rights, it's supposed to be a guard against majoritarian opinion. Isn't this a fact when you have the political level, the legislature, parliament, disagreeing with a judicial decision? Aren't they essentially sort of checking their own homework? Aren't they sort of? Isn't the purpose of the judiciary to check governments when they act in ways that they're not supposed to, or they're not permitted to under the Constitution? So unless we have some kind of limit on the use of Section 33, you essentially give carte blanche to governments to quote unquote override other rights in the Charter by invoking Section 33.
Yeah, I do agree in principle that if Section 33 were invoked as it was in Quebec for 3 years for every single piece of legislation by all 10 provinces and the federal parliament, if that's where we were in Canada, then we would be in a situation where our legislatures always get the final word on rights, and that would make us like we were in 1981 or like we were in March of 1982, and like the United Kingdom, New Zealand, uh, and Australia are right now, which would not be amongst the worst places in the world. So I think it's worth noting, what does it actually look like when a country doesn't have a judicially enforceable Bill of Rights with an invalidation mandate? Of course, New Zealand and the United Kingdom have a Bill of Rights, but the judiciary does not strike down the legislation when it declares that it violates those rights. So that would be the case, but that's not the norm in Canada, right? We're talking about 10 provinces and a federal parliament that collectively pass dozens of laws, if not hundreds, collectively a year. And we've seen 6 uses, 2 of which never even came into or are not currently in force over the course of 6 years. So I don't think we've gotten to a place where this is just the norm and provinces just do it willy-nilly. I think it does demonstrate a general thoughtfulness in terms of their use, and I think that judges can get it wrong. The Supreme Court can get it wrong in their jurisprudence. Individual judges can get it wrong, both in terms of the application of jurisprudence, but just in terms of the sort of rights that they bring in, the values that, or I should say, the values that they bring in making their rights adjudication. So I'm not sort of overly concerned at the fact that on certain instances, 6 instances, 4 of which have remained in place over the last 6 years, we've had the legislature get the final say. And I do think that it is also worth noting that legislatures violate rights all the time in laws that don't invoke the notwithstanding clause, even those legislatures governed by parties who speak positively about the Charter of Rights and Freedoms at all times. So if we think that I think it's a mistake to think, oh, the only time governments are violating rights is when they're invoking the notwithstanding clause. I think it's more refreshing to say, here's a government saying, I disagree with the judicial interpretation or the anticipated judicial interpretation, or just a judicial interpretation that that differs from my own. And I think even in the most egregious use, like Quebec, I don't think this has sort of moved us towards dictatorship. And I'm not saying Leonid is saying that, or all other critics are saying that. But I think that at its worst, we would just be more like Australia, the United Kingdom, and New Zealand, and that's not such a bad thing.
Lena, any response to that? I know you've taught in New Zealand, you're teaching in the UK as we speak. A lot of the folks who criticize the notwithstanding clause sort of point to the fact that it's essentially overriding a judicial interpretation. But we see that's the norm in other countries. Judges don't have the power to strike down laws in these other countries. Is that the end of the world? And does that put Canadians' rights at risk? If we don't have the judicial power to strike down laws, that is completely inviolable.
Is it the end of the world? No, surely not. Does it put rights at risk? Yes, absolutely. A word about the UK, it's worth pointing out that the UK Parliament has, in fact, amended its legislation every single time it has been declared incompatible with the European Convention on Human Rights. So, yes, it was Parliament that had to actually do the change, but the UK Parliament has done at least some changes. They have been admittedly maybe almost cosmetic a couple of occasions, but on the whole, the UK Parliament does in fact take its cues from the courts on questions of rights. New Zealand is a bit different in that regard. But it's also worth noting that in New Zealand, the kind of legislative rush that we have seen time and time again from Canadian provinces raising, barely an eyebrow, in New Zealand, that would not be acceptable. New Zealanders take their legislative process very seriously. By and large, there have been a couple of exceptions over the years, but generally speaking, the way all laws are made, not only those that affect rights, but all laws are made with a lot more consideration, more select committee process, more scrutiny, more thoughtfulness than is the case in Canada. A more independent input from the Attorney General as well. The Attorney General, when providing advice to Parliament on whether proposed legislation is compatible with rights, in New Zealand is acting independently of party politics and is applying a much more rigorous standard than Canadian federal attorney generals are in their scrutiny, and in the provinces we just don't have that at all. So if we are going to go in the direction of New Zealand and the UK, okay, let's get serious about that, and let's take all of the attention and consideration that they put into the process. It sounds to me like what people are advocating in Canada is the worst of both worlds. And the fact that the notwithstanding clause isn't yet invoked for every law, well, we're just getting started.
Well, what do you say to that, Dave?
Well, that's I think I agree again with Leonid that the Canadian legislative process at the provincial and federal level ought to do more rights analysis, and not just rights analysis that says here's what the Supreme Court says and here's how we can best put that view into law. I think that independent rights analysis saying here are the rights in the charter, here's what the Supreme Court has said, and here's where we might disagree with them on that particular right, as something that is not very present in Canadian politics, ought to be much more present. Often isn't there because of the extent to which our democratic politics is executive dominated, especially at the provincial level. But the argument that we should therefore cede all of these questions to a completely unaccountable judiciary who on a 5-4 vote can sort of determine an issue for all time, I think is not the answer. We should encourage our parliamentarians, our parliamentary institutions to be more rights conscious, to be more willing to engage with judicial interpretation, but also to push back against judicial interpretation that they disagree with. But the idea that they're not working very well, so let's just cede it to a judiciary, is incompatible. Incompatible is perhaps too strong, but certainly takes away from our representative democracy and our arguments that ultimately, at the end of the day, these decisions, especially on contested, reasonable disagreement, ought to be decided by our elected parliamentarians, or at the very least ought to have the opportunity to decide those if they see fit.
So shouldn't our representative institutions first show us that they can actually handle us and then start complaining about our taking things away from?
Well, I would say that our representative institutions, our answer shouldn't be let's let the judiciary decide everything, and then once our elected representatives can show us that they're better at their job, like New Zealand elected representatives are, then we'll give them some more authority. Because it would be one thing if the courts were only adjudicating on sort of core rights issues, and the only times the courts were getting involved is if the government banned, the provincial government said you're not allowed to criticize Doug Ford, right? Then we've got a core democratic issue of freedom of expression. But what we've seen over the years is, and I mean, the charter's language has it built right in, that what the courts are doing is determining what constitutes a reasonable limits on these rights. They're engaging in sort of value construction and value-laden decision making. And so I will err on the side of our elected representatives making the correct decisions on that, rather than the judiciary. And again, it's worth noting, regardless of my views on what we are not living in a regime on rights issues where we have untethered legislative supremacy. We're talking about 6 laws in 6 years across all of the different jurisdictions. Have we lost?
I guess Leonid got so upset he jumped up. I'm sure he'll be right back. While we're waiting for him though, Dave, I mean, I wanted to sort of take what you're saying. Well, I think we got Leonid back here. Sorry. We were joking. You were so offended that you dropped off, Leonid. Well, we're glad you're back. I was curious though. I mean, I'm wondering what both your thoughts are on whether or not there's been this sort of rhetorical arms race, so to speak, at the political level. I mean, you look at an issue like in Saskatchewan, we're talking about a policy at a school board about pronouns, but on each side you've got this, and I know Dave, you've written about this rights talk where we've escalated the discussion to we've got this fundamental right of children to identify this way. On the other side, we got this fundamental right of parents, and so rather than sort of having a discussion and acknowledging that there's some trade-offs here and that this is a sticky, because of the rhetorical arms race politically, that this is something that's just absolutely ironclad right that we must protect. That is what throws this into the realm of the court, and that is what incentivizes a government like Saskatchewan to use the notwithstanding clause, because in other words, the politics of an issue escalate to the point where the only way to sort of demonstrate politically that you're taking this very, very seriously is to invoke the notwithstanding clause. Do we have this problem in our politics generally, and is that behind the willingness or the of governments to use a notwithstanding clause?
I guess I'll jump in since you mentioned my paper. I mean, I think that it won't surprise you to know that yes, I think absolutely this is true. That this is something that American scholar Marianne Glendon talked about decades ago. That what a Bill of Rights does, and a judicially enforced Bill of Rights with an invalidation mandate, where the general perception is that courts have the final word, is it creates within a society this rights talk. It creates within a society this willingness, this likelihood to frame an issue in uncompromising absolutist rhetoric, and to say, because you don't budge on rights, right? No one talks about reasonable limits on rights in the media when we're discussing this. And if I were an activist, I wouldn't either. I would say, this is my position, this is my right, and we're not going to budge on it. And what you do is you paint the other side as evil. And I think the Saskatchewan pronoun policy is an excellent example of that. I think, in fairness to the Saskatchewan government, yes, they're engaging in rights talk, they're using the language of rights, they know that it's rhetorically valuable to do so. They are not painting the other side as evil. Now, some proponents of this policy are. We see some pretty awful rhetoric coming from people at protests occasionally, not all people at the protests, but some of them. But we see sort of both sides of this debate using this tendency towards right talk. And it's not just that what a Charter of Rights does is it creates within a society the incentive to engage in rights talk. It also makes the final venue, and the judiciary is, for the most part, every law that's been passed over the last 6 years, instead of 6 times, the final venue is the judiciary. It is the courtroom. And courts literally pick winners and losers, right? They don't say the best policy here is somewhere in the mushy middle, and that's what you ought to do. Sometimes courts can do that. They strike down a law and they tell the legislature, now, if you did it this way, things would be a little better. But most of the time they don't. Most of the time they pick a winning side. And so the courtroom is a venue. It's a winner-take-all venue that encourages, I'm not saying the judges are doing this, it's just the institution itself. It encourages winners and losers. And so we've got this cycle of rights talk and winner take all. And I don't think that's going to change in Canada. I don't think, I'm on the use it side of the notwithstanding clause, but I don't think I'll be sitting here in 5 years saying, well, I was wrong. Every legislature uses the notwithstanding clause for every law, or half the laws, or a third of the laws. I still think that there are very strong incentives in a rights culture, pervaded by rights consciousness, for legislatures not to use the notwithstanding clause, because it's very easy for their opponents to say what they're doing here is anti-rights. They're being anti-rights, they're against rights, they're against the Charter, and Canadians love rights, Canadians love the Charter. So I still expect the notwithstanding clause use to be quite rare, and I think that's because of our politicized sort of rights culture that we have, and that's not going anywhere in Canada.
Leonid.
Well, a couple of things, I guess. One, the last thing Professor Snow said, that's a political calculation. Do you win more votes by accusing your opponent of being anti-rights, or do you win more votes by saying, yeah, I'll just use the notwithstanding clause for different stuff? So I would not be optimistic about that going the way Professor Snow expects. On the more philosophical question, it's true that rights talk is binary. It's one thing or the other, but there are many issues that just are one thing or the other. Either parents have to be notified of a pronoun change, or they don't. And there is, whether we have a charter or not, the nature of this particular question doesn't change. Conversely, compromise is sometimes every bit as evil and unprincipled as people can make it out to be. So if the Quebec government says, well, but we haven't applied our dress code legislation to university professors, or to kindergarten teachers, or to a couple of other people that the Parti Québécois wanted to apply to, look, we are being moderate. No, you're not. You're still imposing the secular dress code legislation, and calling that a compromise is just misdirection. So I just wanted to speak out in defense of rights talk, I guess, both as an analytical matter in some cases, and sometimes as a point of principle.
If I can just jump in there, I think actually on the Saskatchewan pronoun issue, or any sort of province's issue here, that there is actually a compromise between what the Saskatchewan government has done and what a lot of schools and school boards are doing, and what activists are calling for. So on one side, you've got people saying, um, for children under the age of 16, if they want to formally change their gender pronouns and their names at school, and they don't want their parents to be notified, they shouldn't have to. That's one side. The Saskatchewan government, as I read the law, is saying, and I'm looking at my language of the law right here, that parents must provide consent, right? They must say, yes, I allow this. And if they say no, then the teachers, the guidance counselors, formally at school, you go by the old name, you go by the previous gender pronouns. There is a middle ground here that says parents should be notified, right? By the way, we're going to do this at school. And you can't do anything about it, but we're letting you know that we've done it, and we have to notify you because that's the law. I'm not saying that's the best policy. I think both sides of this debate would be unhappy with that. But politics is the art of compromise, and I think this is an example where rights talk and rights language is encouraging both sides to go to, I won't call it extremes, but to sort of avoid that compromise policy, which perhaps may not appeal to everyone, but may end up being a better policy.
Yeah, and I wonder if the challenge here is, and Lena, you alluded to the fact that on some issues there is just a sort of right and wrong. It is black and white, but isn't the issue that there are often other rights engaged, and it's trying to manage the tension of other rights with that right that becomes a challenge. And when we elevate everything to a right, no one. I mean, it's interesting when we talk about the use of the charter and critics of Section 33. I find no one ever wants to say that it's being used to override an interpretation. It's always being framed as overriding a right. And I think, as David mentioned, you don't ever want to be seen to be compromising on rights because a right is sacrosanct. But if you have a collision of two rights and you're trying to find some path between them, it seems to me that trying to find a compromise is the only way forward because, or I think the saying goes, there is no solution. There are only trade-offs. Um, I did want to talk a little bit too about maybe something structurally, and this would also apply to the United States here. I'm curious to get your thoughts from both of you on whether the fact that we're a federal country, we have a federal structure, do you think that this exacerbates the temptation to use Section 33? That's to say, it just provides more points of political conflict, and so if Section 33 is tempted, it provides a temptation to use as like a political stick. The fact that we have a lot of federal provincial strife and tension over various policies, does Canada as a federal country, as say compared to the United Kingdom or New Zealand, do you think that might be one of the reasons, or that Section 33 becomes attractive as a sort of a political tool?
I have some difficulty seeing the connection, although Professor Snow suggested one, and that was an interesting argument. So he said earlier that it's maybe because the more conservative governments in the provinces are looking at judges who are appointed by a liberal government in Ottawa, and as we are probably going at least some distance in the direction of a more polarized approach to law, which Canadians for a long time thought that was just something that the Americans had and we did not. But I think we are going in that direction. So maybe that does connect to federalism in the way that Professor Snow suggested. Uh, Other than that, I think it's partly, we maybe should have this conversation in 5 to 7 years after a few years of Poilievre government, and if they turn out never to use the notwithstanding clause, that will be interesting. I will be surprised, and I don't say this to cast aspersions on Mr. Poilievre, but many other conservative leadership candidates over the last several leadership races promised to use the notwithstanding clause for all sorts of things like pipeline protests and whatnot. I mean, sometimes it was really a sort of demonstration of political toughness. So I suspect that Mr. Poilievre will be tempted to engage in a demonstration of this sort over one thing or another, in the similar way to what Mr. Ford has been, or the Saskatchewan government. Uh, but if that doesn't happen, I guess that will be points in favor of Professor Snow's hypothesis.
I actually am again inclined to agree with Leonid. I would expect Poilievre to come in and use the notwithstanding clause, probably on legislation related to criminal law. He said last year, or during the leadership race anyway, that he would use the notwithstanding clause in response to the Supreme Court's, I will say, egregious Bissonnette decision, in which it struck down the ability of the federal parliament to have multiple life sentences for 25 years for mass murders. I think that is actually a great example of why we should have the notwithstanding clause. In that decision, the Supreme Court says this would offend the values of Canadians, and I would like to see some polling data showing that Canadians' values are offended, that Alexandre Bissonnette, who shot up a mosque, should spend the rest of his life in prison. And that was actually a unanimous decision, including many judges who were appointed by the Harper government, in fairness. So that's a bit of an aside, but I think that obviously, I think it's true that the ideological uniformity perceived between judicial decisions, the federal government, and the federal appointment power over judges does go some way to explaining the use of the notwithstanding clause. I'll make a prediction, since Leonid did as well. I would not be surprised to see the Alberta government introduce some legislation containing the notwithstanding clause in the coming years under Danielle Smith. But I also think it's important that we should not be ahistorical about this. This is why the notwithstanding clause was included in the charter. Alan Blakely and Sterling Lyon and Peter Lougheed, the Prairie premiers who were so adamant about the notwithstanding clause, they didn't want it there because they wanted to make sure that Pierre Trudeau could respond to the Supreme Court of Canada ruling and use the notwithstanding clause for federal legislation. They were concerned that this Bill of Rights, this constitutional Bill of Rights, this judicially enforced Bill of Rights, would, yes, allow courts to have the final say, and they found that problematic, but specifically the final say with respect to areas of provincial jurisdiction. Because what the Canadian Charter of Rights and Freedoms does is it centralizes, right? And the notwithstanding clause was designed to combat centralism. And there is a debate in the academic literature on this, and I clearly fall on one side, but when a court strikes down a law in an area of provincial jurisdiction, something like collective bargaining rights, right? Something like a law banning a particular public sector union from striking. When they strike that down for being an unreasonable limit on charter rights, that is the application of national standards, even if we like it. And I'll point to a law that I really like, or a case that I really like. MVH 1999, the Ontario Family Law Act had a heterosexual only definition of spouse that said spouse is only, you're only a spouse of a man and a woman, heterosexual only. And the Supreme Court said, no, that violates our equality rights under the Charter, violates the equality rights of gay and lesbian couples, and you need a same-sex definition of spouse as well. I think that's good policy. I think that's a good decision, but that was obviously the application of national standards across the country. The federal parliament needed to amend all its laws. The provincial legislatures need to amend their laws. So I deliberately use an example of a court case that I was fond of the outcome to show that on these rights issues, is when a Supreme Court or even a provincial high court that doesn't get appealed, when they strike down a law, inevitably the result is an area of provincial jurisdiction has been eroded. The jurisdiction has not gone to the federal parliament, but it's just gone to this charter space where you can no longer legislate there. And that's what the framers of the charter, the premiers, were concerned about. So it shouldn't surprise us that it's the provincial premiers who are most likely to invoke the notwithstanding clause. And it shouldn't surprise us that this is happening in the provinces where the sort of ideological difference between the judges and the government of the day is
higher. I wanted to. You mentioned disallowance a little bit earlier. We got someone in the comments who argues that the power is not obsolete. Now, I'm curious. There are some advocates too. I know several commentators have said, they've suggested that yes, in fact, to combat this rising use of Section 33, the federal government should actually revive the power of disallowance. So I don't know if you see that as an unwelcome arms race. How do you respond to that?
Two wrongs don't make a right. As simple as that. And Like I said, I do think the use of the notwithstanding clause is wrong, even against cases like the Bissonnette case, which I fully agree with Professor Snow. I've written about it. It is egregious. It was shocking, although not altogether surprising. Sadly, amend the thing, amend the Constitution, and solve it that way. But disallowance is equally, if not more, but at least equally objectionable, for partly similar reasons, because it appends the constitutional settlement to which we have arrived in practice, not words on the page, but the one that actually existed. It appends the constitutional settlement at the behest of a majority and against minorities. So that is also a similarity as well. Local minorities as opposed to minorities defined along some other lines, but definitionally, then it's a national majority against the province. No, just don't.
Yeah, once again, I've got to agree, and I got to say, one of the reasons I'm so happy to be with Leonid as my interlocutor on this panel is I think that you offer the best opposition to the notwithstanding clause I have seen, which is to say, I don't like it. It's bad for all these reasons, and so we should discourage its use. Because what we see a lot, I saw Peace and Policy Options the other day arguing that every time the government invokes the notwithstanding clause, or the legislature does, we need to create a representative jury of citizens. We've seen this argument that it should be disallowed by the federal government if it doesn't go with our international human rights obligations. We hear this argument a lot that the notwithstanding clause should not be used preemptively, only reactively. Of course, almost 90% of all uses of the notwithstanding clause have been preemptive, and that doesn't even count the omnibus use. And I think that sort of, those proposals are too clever by half, because what they're trying to do is get around an established constitutional settlement. And so I'll put on my other hat for a moment and I'll say, pretend for the moment that I agree that the notwithstanding clause is a bad thing. What can we do about it? I don't think the answer is try and put in place these rules, try and get the Supreme Court to change its mind from 30 years ago jurisprudence, try to bring back the federal power of disallowance. I think that if you think the notwithstanding clause is bad and you think that the judiciary ought to have the final say at all times on these rights issues, then what you want to do is change hearts and minds. What you want to do is tell governments, you're going to be punished for doing this. Tell people this is wrong, and ideally get the provincial governments and the federal legislature, federal parliament together to amend the Constitution to take it out of the Constitution. That's a far more honest way to go about limiting the use of the notwithstanding clause.
I guess we've only got a couple minutes left, so I mean, I guess I'll just ask the straightforward question. You know, we dance around it, Buzz, but do people's views on the legitimacy of the notwithstanding clause really just boil down to a preference for judicial supremacy versus legislative supremacy? Is at the end of the day, someone needs to have the final say on these issues, and it either has to be a court or it has to be our elected representatives, and there's pros and cons to both of those things. But is that the core issue when we're talking about legitimacy of Section 33?
Well, yes, but it is always the elected representatives who have the final say, because they can amend the Constitution. But there is a high threshold for doing that. You want to say that the right, for example, the right to freedom of expression does not include the right of civil society to advertise on political matters for a year outside of election campaigns, which is what the Interior Government has said. Amend the Constitution and make that clear. So it is about honesty and transparency. But short of that, yeah, I think that opposing the use of the notwithstanding clause is about saying that by no means in every case, but on the whole, we will do better to have the judiciary with the presumptive last word on what rights mean. And I think, if I may, the people who support the use of the notwithstanding clause think that we are, on the whole, better with the legislatures always at least having the option to come in, even if they choose not to do it in every case.
Yeah, I think that what I actually advocate for, and I'm going to quote from something Leonid wrote before, because it's a wonderful piece that I assign in my textbook, in my classes, where he sort of reinforced this point here, saying that there isn't some sort of happy Canadian middle ground between parliamentary sovereignty and judicial enforcement of constitutional rights. And that's actually what I want. And I think that the UK and New Zealand do a much better job getting towards that happy middle ground for a variety of different reasons, both because of the type of Bill of Rights they have, because of what Leon had mentioned about the sort of culture within the legislature and the practices within the legislature of protecting rights. But I'm actually not one of these people who says, I just wish we didn't have any Bill of Rights, any Charter of Rights and Freedoms at all. I think the more we can get to like an actual dialogue, not a dialogue where the judges tell the legislatures what to do and one out of every 1,000 times they disagree with them slightly, but an actual dialogue on these rights issues, then I think that is the best of both worlds. And I think that the New Zealand United Kingdom frameworks do that a little better than Canada does. But so I'm still sort of hoping for this happy middle ground. I am aware of the fact that there are many out there who say you kind of end up one way or another, and we'll just see what the next several years where they bring us in terms of that for Canada.
Great stuff. Well, gentlemen, we're at the top of our hour. I want to thank you very much, both of you, for joining us. It was an outstanding discussion. And again, Professor Dave Snow at the University of Guelph and Professor Leonid Sirota, University of Reading. I want to thank them both for joining us. And I want to thank you, the viewers, and we'll see you on the next webinar.
Thanks, Aaron. Thank you, Dave.
Yes, thank you both. That was great.